All right, are we ready to begin? What about Ryan Is he?
Your Honor, he is not here. I visited with him at length yesterday.
We have 5 different cases on
Something technical.
Mr. Daniszewski. Where do we stand on these?
Your Honor, Ryan and I, as I told the court, spent a considerable amount of time yesterday. Ryan, what you and I talked about has been conveyed to Mr. Etheridge, and the answer, at least at this point, is no. So, Your Honor, what we had agreed to, his bond would now be set at $15,000, and with the usual stipulations of drug testing every Monday morning. David, he would be living with his mother in Sharp County. So how are we going to work that?
You know, the state has concern, of course, about his activities. We do not object to a reduction of the bond. The court finds that appropriate. We do want him to live and know where he's at. We also want him drug tested, Your Honor, because his activities have not indicated he understands the significance of what's happening here.
Well, I'm just trying to get through all 5 of these cases and see what the charges are. I honestly don't remember from whatever other times he's been in court. So, Mr. Henderson, we have him scheduled for trial on some of the charges in April. Is that correct? The week of April 23rd. All right, so the proposal is to set his bond at $15,000.
To cover all...
Cash or surety covering
Yes.
all 5 of these, is that
Yes,
correct?
Judge.
Where would he be living?
Your Honor, he would be living with his mother. Her name is Donna Tharpe, Tharpe, at 30 Melody Lane, and 30 Melody Lane in Williford, Arkansas, which is just on the other side of Ash Flat. According to Mr. Kinsley, this is residence that Ms. Tharpe has had for at least the last 4 years.
All right. The next appearance in court will be ordered, the court will approve that bond. The next appearance in court I have listed as the 8th of March, a month from today. That's it.
May I request to have a reappearance in 2 weeks if I haven't made bond yet, to discuss another reduction?
Well, let's see.
You know, the state would say that the state will not agree to any further reductions on Mr. Daniszewski's situation.
Well, I'm gonna leave it where it stands. The next appearance date in court right now on our scheduling order is March 8th. It's a pretrial date in some of the cases, and it's just a reappearance date in some of the other cases. We'll have it at this point. The bond is set where it's going to be set at this time. You may be excused at this time.
At 15,000?
Yes.
At 15,000.
That covers all your cases, Ryan.
Right. Yes, sir. Thank you.
2017-348, State of Arkansas versus Donald Drebber.
You know, I think Mr. Dreggers reappears today. I believe he was in Care Center, and obviously he has left that program.
All right, matters down for, this is a pretrial hearing date, or any pretrial issues to take up at this time?
Yeah, there's no pretrial issues.
Oh, this isn't the date, that's the 22nd. I'm sorry. His pretrial is set in 2 weeks on the 22nd.
You know, we had asked him to be brought back today because he had been released to Care Center Ministries.
Right.
And so we told the court, we'll always notify the court when it takes place to bring him back for an appearance.
All right. Well, he's on for trial the week of March 26th. His plea deadline is March 22nd. His pretrial hearing date is February 22nd. And so we'll proceed on that basis. Is there an issue of bond?
Your Honor, I was going to inquire the court, what does the court show that his bond is set at?
$2,500, Your Honor, was the initial bond.
All right. Let's see.
Keith, your bond is $2,500 cash or pro?
Yes. All right. That's the bond. You may be excused. 2017-382, State of Arkansas versus Don Lambert.
Your Honor, for now, there's going to be no action on Ms. Lambert. We were hoping, and Don, we may get there before the day is over, that her mother was going to be here to make a statement to Mr. Etheridge and hopefully to the court. Her mother has not arrived yet. If that would happen, I would notify the court and we could recall the case. But at this point, I wouldn't ask it to be recalled.
Okay. All right. Your next appearance in court, Mr. Lambert, is scheduled for March 8th. You have a trial setting during the week of April 23rd, and that March 8th date is a pretrial hearing. You need to stay in touch with your attorney and be back before the court on March 8th. You may be excused at this time. This is 2018-32, State of Arkansas versus Brandi Barnes.
You know, when I visited with Mr. Barnes, he had not applied for us. I gave him a form. Would the court inquires if he's filled that form out yet?
Have you filled out and turned in your application for the Public Defender's Office?
Yes, sir.
Okay. When did you get that turned in?
Yesterday.
We checked this morning, Your Honor. If he's filled it out and given it to the jail, it's not his fault. Your Honor, this is on a simple reappearance. We've been appointed on the revocation. I would assume that we'll be appointed on this.
There's a revocation as well.
I believe there is, Judge.
In any case, on 2018-32, Mr. Barnes' case is set in July with a pretrial set for March 8th. Court will simply down to reappear on March 8th as his next appearance. Until that application gets through to the Public Defender's Office and the appointment can be made, there's really not a lot more we can do at this point. So that's where we are.
Your Honor, Mr. Barnes and I had discussed bond, but what I'm informed by the prosecutor's office through the probation office is that there is a hold on him because of the probation.
Okay.
And they are not willing to lift that hold.
So we just need a date when you can hear his revocation hearing.
I don't have that case in front of me at this time. What's the number on that case?
2017-155.
Okay, let me get that.
That may have to come back in front of Judge Putman. Judge, that's a Judge Putman case.
We'll just have him appear next week.
We'll have him appear and we'll get a court date.
I'll set it down in front of Judge Putman on February 15th. All right. So Mr. Barnes' next appearance in court actually will be on February 15th in front of Judge Putman in case 2017-155. You said 55, is that right?
155, Your Honor.
155 on the revocation hearing. The next appearance in this court on the charge 2018-32 will be March 8th. You need to stay in touch with your attorney as soon as that appointment gets made. You may be excused.
Yes, sir. Thank you.
2018-58, State of Arkansas versus Jacob Langston.
Yes, sir.
This appears to be a first appearance on charges of possession of a controlled substance, methamphetamine or cocaine, possession of drug paraphernalia, separate possession of drug paraphernalia for methamphetamine or cocaine. Both of them are Class D felonies. On those charges, Mr. Langston, is he represented?
Yes, we've been appointed, Your Honor.
Noting the Public Defender's Office is representing him on those charges, how does he now plead?
Not guilty, Your Honor.
Plea of not guilty is noted here on the record.
I believe from our notes that there is a parole violation that he's dealing with, so bond is not an issue today.
Okay. This case will be set down on this court's scheduling order. Court will be setting the case for the week of July 16th. July 12th is a pretrial date. Is a plea deadline date. Be set for May 3rd as a pretrial date. And the defendant's next appearance in court will be March 8th. So your next appearance in court will be March 8th. You may be excused at this time. Court is calling 2018-44, 2018-60. State of Arkansas versus Andrew Beier. Mr. Beier, it was previously arraigned and is set on the court's scheduling order for 2018-44. He's down in the trial during the week of July 16th, with the next appearance in court will be on March 8th. To check on the status of the case. In 2018-60, he's not been arraigned at this time and not gotten on the scheduling order. The case is, the charges are possession of controlled substance, Schedule 2, methamphetamine or cocaine, Class D felony, and fleeing on foot, misdemeanor. Mr. Beier, have you made arrangements to be represented by counsel on this matter? Have you applied to the Public Defender's Office or hired an attorney?
Your Honor, he's not applied to us that we've received.
No, I have.
Let's see. On either of these cases? He doesn't represent you in 2000. Public Defender's Office doesn't represent you in 2018-44, which you've already been arraigned on. Now let me look it up. No.
Your Honor, we don't show that he's applied on either case.
Apparently he did not appear on February 1st when Judge Putman called his case, and it was set over for arraignment today on both cases. I thought he'd been arraigned already on the first one. Mr. Beier, have you made any application for Public Defender's Office, or have you sought to be represented by an attorney?
No, sir.
Well, you've got two sets of fairly serious charges. I think it's probably, I'd strongly recommend to you that you make arrangements to be represented by an attorney. The way that works is you go out and hire the attorney of your choice, and the court doesn't get involved because you have this right to an attorney and you're going to hire private counsel. The court doesn't get involved. The court only gets involved if you determine that you cannot afford to hire a private counsel, in which case you need to fill out an application for the public defender's office applying to have court-appointed attorney. Until you fill out that application, one's not going to be appointed for you. So you'll need to get busy on that if you want to be represented by an attorney. What has to happen is you have to fill out the forms. The forms are available there at the jail, and then you take those form, fill it out, and turn it in at the jail. It'll get back to the public defender's office, and they'll arrange to have a judge appoint counsel for you. So that's how that works. But until you get that done, that's where we are. Court's setting these matters down. They're both on my docket. I'm setting them both down by scheduling order for trial in the month of July with a pretrial hearing date of in May 3rd and a reappearance on March 8th to check on the status of the case. So that's where your cases stand at this time. Do you have any questions?
No, sir.
Okay. On the first case, the bond apparently has been, on 2018-44, bond has been set at $10,000. The information in 2018-60 reflects a bond of $2,000.
Your Honor, that's an error. That should be $20,000. Actually, my office is moving to revoke this man's bond that he put in the first charge. So I'd caution him about making any bond. We arrested this gentleman in January. Approximately, he made bond, got out of jail. He was arrested approximately 10 days later. And so that's in the works. It just hasn't happened, Your Honor. You haven't seen the petition.
Well, court's going to go ahead and make the bond $20,000 cash or professional on both counts, on both separate charges. As I understand it, he posted the $10,000 bond, and if he wants to make arrangements with whoever bondsman undertook that obligation, that bond is no longer good. The bond is now $20,000. It'll cover both cases. It'll require that the defendant not possess or use drugs or alcohol in any fashion while out on bond. I don't know anything more about his circumstances or any other conditions of bond that might be recommended, but
Your Honor,
that's where I'm going to set it.
If we could have one other condition of that. This gentleman is driving an automobile. We've caught him twice now driving automobiles without liability insurance. That's going to get somebody hurt. What's more, it's going to get somebody hurt without the ability for anyone to get paid for it. I'd like some restriction that says this gentleman, so it shows some sort of ability to insure the vehicle that he's driving, but he not be driving.
But you know, that's already a legal prohibition, but I'll make it a condition of his bond that he not operate a motor vehicle without liability insurance. So that'll be the order of the court. Your next appearance in court on both of these cases is March 8th. You may be excused at this time. (2018-62) State of Arkansas versus Michael Ford. Mr. Ford, you're for arraignment today on charges of possession of controlled substance, methamphetamine, or cocaine. That's a Class C, charged as a Class C felony. Before we do an arraignment, have you made arrangements to have an attorney represent you?
No, Your Honor.
Okay.
Your
Well,
Honor.
what's your intention in terms of being represented by an attorney?
What?
Judge, he has used us in the past. I would anticipate that when he has an application, and we'll make sure that he gets an application, that he'll fill it out and will be appointed.
All right. Mr. Ford, what the court's asking about is whether you've taken any action to secure an attorney for yourself. You're in prison, you're in jail facing serious felony charges. You have an absolute constitutional right to be represented by an attorney. But just sitting there in jail and doing nothing, attorney just isn't going to walk in on you. You've got to take some action. What's assumed you'll do is you'll go out and hire the attorney of your choice, in which case the court doesn't get involved. The court has nothing to do with that. That's your private hire of an attorney of your choice. However, if you cannot afford to hire an attorney, and apparently in the past Mr. Cooper indicates that you've used the service of the Public Defender's Office, and that the Public Defender's Office comes to you by appointment of a court, and it will not happen until you initiate the action to apply to the Public Defender's Office. So in the strongest terms I can do it, I'm recommending to you that you fill out the applications that are available there at the jail for the Public Defender's Office, get that filled out and turned in so that the next time you're in court, you'll have a pretty good chance of having an attorney with you. Now, in the meantime, on the arraignment, the court is arraigning you on a charge of possession of a controlled substance, Schedule 1 or 2, methamphetamine or cocaine. It's charged as a Class C felony. On those charges, how do you now plead?
Not guilty.
I'm entering your plea of not guilty. I'm once again recommending you apply to the Public Defender's Office. This case will be set on my scheduling order for trial during the week of July 16th. You'll have a pretrial date of May 3rd, and next appearance in court will be March 8th. You may be excused at this time.